Very good. Mr. Brannick and Mr. Crabtree, I see you have both entered our virtual courtroom, so good morning. I do want to go over with you the timing to make sure that I keep track of things correctly. For these two cases, you're going to argue them in a combined fashion. We have granted an enlargement of time, which of course you do not need to use all that time if you see that you have made all the points you have made. But I want to go over the order, and then if you wish to reserve rebuttal time, I want to make sure to jot that down correctly. So we have the appellant represented by Mr. Brannick in both cases is going to go first. Mr. Brannick, you have the opportunity to reserve some time for rebuttal of the initial case. How much time would you like to reserve?
10 minutes, please, Your Honor.
After the initial argument, then Mr. Crabtree, you will proceed with both your response to the initial argument as well as any argument that you have on the cross appeal. We will then go back to Mr. Brannick for his time on rebuttal. And then Mr. Crabtree, you have time for rebuttal on the cross appeal. How much time do you want to reserve for that? You're on mute, Mr. Crabtree.
5 minutes, Your Honor.
5 minutes, very good. All right, well, I will do my best to deal with the challenges of a different time frame, but we are ready to proceed if you are. So Mr. Brannick, I've got you down for the 10 minutes reserved for rebuttal, so you may proceed. I'm giving you on the clock 30 minutes.
Morning, Your Honors. May it please the court. I'm Steve Brannick of Brannick, Berman and Sider here representing the former wife, Ashley Kozel. We've actually got 4 appeals on the docket arising out of the family law case below. The first 2, of course, we're arguing together as we've just discussed. And those first 2 cases concern the trial court's decision that it was powerless to sanction Todd Kozel and his new wife, Inga, for their misconduct during the supplemental proceedings after the parties' divorce. So let me dive right into that issue. Of course, the issue is that the sanctions were incurred while Ashley was attempting to collect on her judgment. But this court ultimately reversed the money judgment against Todd on very narrow grounds, holding that the trial court had not been granted the power by the parties' property settlement agreement to grant a breach of contract judgment for money damages. But the court then affirmed the balance of the judgment. Now, based solely on the conclusion that the court didn't have the power to award a money judgment, the trial court then vacated the sanctions orders, convinced that if Todd didn't have, convinced by Todd that if the court didn't have the power to enforce a money judgment, then everything it did in the continuing proceedings was void.
Mr. Brannick, let me ask you a question. Both sides cite frequently to 212 West 18 LLC versus Kozel. Why does that case not cover the current situation?
Because in 212 West, the sanction that was presented to the court was essentially awarding Ashley's judgment against a third party. And if the court had determined that the original judgment against Todd was not enforceable, then certainly that judgment was not enforceable against a third party. So it was simply the conclusion that you can't enforce that derivative judgment. That's very different from the issue of enforcing sanctions that for misconduct that took place during the course of the proceeding. The decision of this court that addressed that issue was the contempt appeal by Todd. In that case, this court was very clear about the law. And it said, here's what the court said. Todd had argued in that case that because the original judgment was on appeal and was going to be reversed for lack of jurisdiction, there was no jurisdiction to sanction him. This court was very clear that Todd was wrong. This is what the court said, quote, "We recognize that Mr. Kozel is presently challenging the merits of that injunction and an underlying judgment in a separate appeal pending before this court. But that really is of no moment for our disposition of this appeal. Regardless of the injunction's propriety, the order must be obeyed until vacated or modified by the trial court or until it has been reversed on appeal, no matter how unreasonable or erroneous. So the decision by this court addressing the sort of sanctions that we are dealing with now, in fact, addressing some of the very sanctions orders that are in front of this court, was clear that it is of no moment that there might be ultimately determined that there was no power to award that judgment, as long as that order was in place at the time and it was disobeyed, and it's clear that those orders were in place at the time they were disobeyed, then the court clearly has the power to award sanctions. What I'd like to do is kind of talk about what I think is the easiest way to resolve this case. I think the subject matter jurisdiction versus concurrent versus continuing jurisdiction or procedural jurisdiction is an interesting issue. Obviously more complicated, but there's a very simple way to decide this case, which is this is a family law case. And as we all know, trial judges in family law cases have continuing jurisdiction over the parties to enforce the judgment and to deal with issues such as alimony and child support. And to me, that's all this court needs to know to enforce these sanctions. This court had personal jurisdiction over the parties. There's no question that the parties were indisputably before the court. And the court had subject matter jurisdiction. It had its traditional family law continuing jurisdiction over the parties. And they concede this. They even concede that the court had the power to enforce the property settlement agreement and the power to interpret the property settlement agreement. So the parties were properly before the court.
Mr. Brannick, but these sanctions weren't imposed in conjunction with the motion to enforce the PSA, correct? Is that, I mean, that's the whole issue, right? This wasn't actually a motion to enforce the PSA at the end of the day. At the end of the day, it was effectively a breach of contract action for damages that more properly should have been brought in the separate action in circuit court.
Well, the way I would put it, Your Honor, is that Todd is basically arguing that all of his misconduct had nothing to do with his traditional family law support obligations and was only in connection with the effort to enforce the judgment on the property settlement agreement. So I can commit all the misconduct I want in connection with your attempts to enforce the judgment, and you can't touch me. But the misconduct, and none of my misconduct had anything to do with my child support obligations. I don't think that you can so neatly separate his misconduct in that way. The whole time
he lost on that, right? And he's cross appealing. The court didn't vacate. Mr. Kozel is appealing the refusal to vacate the promissory note order.
Right.
So he did lose on that, right? Because that was found to be related to the child support issue.
Well, he lost on that.
Clearly within continuing jurisdiction.
Right. He lost on that, but I think the point I'm trying to make is that the trial judge didn't really understand the significance of that ruling. Todd should have lost on all of those issues for exactly the same reason. The whole time that he was ducking his enforcement obligations and committing fraud on the court, he was also behind in his child support obligations. And so how did he argue that he was behind in his child support obligations? He argued that I'm broke. I don't have any money. He argued that he had no ability to pay. And that argument about having no ability to pay is equally applicable to his traditional support obligations as it is to the enforcement of the judgment. Let's say the judgment didn't even exist. The parties would still have been before the court. And I think you can see by the long history of the way that Todd litigated this case, the parties would still have been in front of the court arguing about his failure to pay child support. And Todd would have been making exactly the same arguments that he had no ability to pay the child support. I think our simple point is that if you are a family law litigant and you have support obligations, your finances are always on the table. a key issue in every issue in continuing jurisdiction in family law cases is whether the party has the ability to comply with their obligations. And so if you are making arguments to the court, regardless of the context, that you have no ability to pay, and those arguments are false, and those arguments are fraudulent, then the court clearly has the power to sanction you. And to try to parse those by saying, well, my lies were only directed to this issue and they weren't directed to the other issue, so Judge, you don't have jurisdiction to sanction me. I think that's absolutely a bridge too far. So the trial judge absolutely got it right on the Al-Kabandi notes, but the trial judge just didn't get it right enough. The trial court should have recognized that all of the arguments that Mr. Kozel made, that Todd Kozel made, that related to his ability to pay or his so-called inability to pay were exactly at the heart of traditional family law jurisdiction. If you're going to plead poverty to a trial court, a family law court, and you've got obligations outstanding, and 7 motions for contempt are brought against you because you're behind on your child support obligations, I don't think you can come before the court and argue that you can sanction me for some things, but not for others. The court had jurisdiction over Mr. Kozel. The court had jurisdiction over this case, and any fancy arguments about subject matter jurisdiction versus continuing jurisdiction, I just don't think enter into this at all. So I think the simple way to resolve this case is by recognizing that everything the trial court did was designed to force Todd to be honest about his finances. And if trial judges don't have the power to do that, if family law judges don't have the power to do that, then I think we are in very big trouble in family law litigation. But now, so I think I've said my piece on that point. Let me talk a little bit about this procedural jurisdiction versus subject matter jurisdiction. There's a very simple principle in play here, which is that the parties have an obligation to obey the order of a court, even if that order ultimately turns out to be erroneous and is reversed. And so we all know that it's typically no defense to a contempt or other sanctions order that the trial court got it wrong. And at the end of the day, that's all that happened here. The trial judge was wrong in its interpretation of the property settlement agreements enforcement remedies. But that error is no defense. It's not like a lack of subject matter jurisdiction where everything you do because there's a lack of subject matter jurisdiction is void. And how do we know we're not talking about subject matter jurisdiction here? Because the original Kozel case on the merits specifically said so. Judge Solario was very careful to distinguish between what was going on here and a lack of subject matter jurisdiction. As I talked about already, it's clear that the court had jurisdiction over the parties. It had personal jurisdiction and it had enforcement jurisdiction over that property settlement agreement. So the court said that this court had subject matter jurisdiction. It's just a matter of continuing jurisdiction. And
so as a practical matter, jurisdiction is something you either have or you don't. So I don't quite, is continuing jurisdiction sort of like jurisdiction light? Obviously you have jurisdiction to do some things. If you have subject matter jurisdiction, you're not completely deprived of your jurisdiction over the case itself or that type of case. But how do you draw that line? It seems to me that the trial court said everything that arises out of this action over which I did not have continuing jurisdiction, everything that exists but for, that would not have existed but for this action over which I did not have continuing jurisdiction is now a nullity. That strikes me, you were saying earlier, there's a clean and simple way of looking at this, and that strikes me as the cleanest and simplest. So tell me what I'm missing.
Yeah, I think the problem here is when we focus too much on vocabulary. I think the one thing we can all agree on is if you look at all these cases and try to figure out whether a court's meaning subject matter jurisdiction in which everything else is void or some sort of jurisdiction light, as your honor put it, or procedural jurisdiction. I think it gets difficult. Where it gets very easy is if you look to see what's happening in the particular cases. So if you look, we've cited a couple of cases, the U.S. Bank v. Anthony Irish case, the 14302 Marina San Pablo case, and the Spencer v. Marshall case, all of which are cases that involve continuing jurisdiction, where the court specifically distinguished continuing jurisdiction from subject matter jurisdiction and determined that the actions that the trial court took while it had that continuing jurisdiction were not void. Void decisions are decisions for lack of subject matter jurisdiction. Void decisions don't arise out of a trial court who has the power to make a call, making the wrong call. Then look at what's happening in the cases that he cites. And don't worry about whether they use the word continuing jurisdiction or subject matter jurisdiction. Look to see what was happening in those cases. In the Synchron case, the trial court order was determined to be void because there was no personal jurisdiction. Well, that's obvious. Everybody agrees with that proposition. There was only a discussion in that case because there was an academic disagreement between this court and the Fourth DCA on that issue. But for our purposes, yes, everybody agrees that if there's no personal jurisdiction, then the actions that the judge takes are void. So Synchron's easy to deal with. Abdo is the same way. This court saw the Abdo case twice. In the first case, it determined that there was no personal jurisdiction. It went back to the trial judge, and the trial judge, despite this court's ruling that there was no personal jurisdiction, exercised jurisdiction over the party anyway. Again, there was no personal jurisdiction, so everything the trial court did was void. Another very easy case. If you look at the Pulte case, that was a case where there was no reservation of any power whatsoever to enforce the settlement agreement. And without the reservation of any power, then anything the trial judge attempted to do in connection with that enforcement of the settlement agreement was void. The court had no power to act at all in the Synchron case, in the Abdo case, in the Pulte case, the same in the Schmidt case. In that case, a party tried to file an amended complaint in a case that had long been resolved and affirmed. Essentially, they were trying to file an amended complaint in a dead case. Again, the case was over. The trial judge had no power to act. So when you're looking at these cases, the question you need to ask yourself is this a case where the trial judge had no power to act at all? And if that's the case, then it's easy. The judgment and everything that the trial judge did after that is void. But is this a case where the judge did in fact have the power to make a call and just got the call wrong? If that's the case, then we're talking about something that's voidable and not void. That's a distinction that runs through Florida law throughout its history. And the only reason there's any confusion on this at all is just the vocabulary. But again, look to see what happens. And to me, it's very simple. In this case, Todd concedes that the trial judge had the power to enforce the agreement. Todd concedes that the trial judge had the power to interpret the agreement. The trial judge just got it wrong. But if you had the power to act, then everything you do is not void. It's just voidable. And it's as simple as that. So,
Mr. Brannick, do you draw a distinction between Mr. Kozel's situation and Inga's situation, where she was simply brought into this case as a result of proceeding supplementary on a judgment that was not enforceable?
I don't see them as any different, because the question is, was she in front of did the court have its traditional family law enforcement jurisdiction, supplemental jurisdiction?
But she was not a party to the marital dissolution. She wasn't a party to the PSA. She wasn't a party to the final judgment. She is brought in purely on a new matter for which our court held the court did not have authority to act.
Right. But the question you have to look at is, what was Inga Kozel accused of doing? And she was accused of helping Todd make his bogus argument that he had no money. And so she was part and parcel of this argument that Todd did not have the ability to pay his family law obligations. And again, that goes back to—
She wasn't impleaded, though, in relation to this general concept of child support, let's say. She was brought in specifically as a result of the judgment that our court determined was invalid.
But whether you're a third party or a party to the case, you can't lie to the court. You can't commit fraud to the court. And that fraud that she committed went to the heart of family law jurisdiction, which is determining the nature of the parties' respective assets, that the court can come to a fair decision on enforcement, alimony, child support, and everything else. Just to give you a simple example.
Did our court in the 212 case, where the court says that we're not really going to address these arguments, but then the court reverses the judgment against 212 because the underlying judgment was determined to be invalid?
Right.
So did it get it wrong? Do we have to go en banc to recede from that? Or is there a way to distinguish it in a meaningful way?
No, I mean, I think 212 is a much easier case. If the underlying judgment has been reversed, then a third party can't be on the hook for an underlying judgment that was reversed. I think that's all.
But that's not the only thing. That's not the only thing it decided. It also decided that the third party could not be sanctioned for fraud in relation to that underlying judgment that was overturned.
But the sanction was the striking of the parties.
It's a sanction for commission of fraud on a court.
Right. But here's the difference. Look at the contempt sanctions that this court affirmed. That was the sort of case that was exactly the same as we have here. In fact, again, it's some of the same orders. In that case, the fraud on the court caused the other party in the case to suffer damages and losses because the litigation became far more complicated than it needed to be, because Ashley was having to spend also, hundreds of thousands, if not millions of dollars, chasing down Todd's fraud. It's very easy to tell a lie to the court. It's much, much more difficult to untangle that lie. And so she was awarded her fees and costs as a result of those lies. And that went up to this court. And this court, in its contempt order, said it doesn't matter, Mr. Kozel, that you think ultimately those orders are going to be reversed. All that matters is those orders that you disobeyed were in place at the time that you disobeyed them. That's all we need to know. That's the case that's on all fours. That's the case that should guide this court, not the 212 West. Because in 212 West, essentially, if you enforce those sanctions, you would be requiring the third party to pay that judgment. And I think that was
am I recalling correctly, though, that in the case with Todd, that the court focused on the child support issue?
In one of the orders, yes, the trial judge actually affirmed the sanctions order because making the specific finding that it was connected to the child support issue. My point is that everything that Todd did related to his argument was that he was broke.
But you're saying the other Kozel case involving Todd is really the most instructive one. But
yes,
that case specifically dealt with the child support issue. And the court had the
more
power.
than the child support issue. Child support was one of the issues, but also it dealt with other frauds that he had committed on the court. I mean, in my opinion, everything he did is relevant to the child support issue because it was an argument about his inability to pay. But if you're looking at the specific sanctions that were on appeal in those the cases, one was the child support, but there was also the failure to satisfy the escrow requirements, failure to provide a detailed accounting, failure to appear at a deposition related to the attempt to enforce the judgment against the condominiums. So there was a number of sanctions that Todd would certainly argue that had nothing to do with child support. This court had no trouble affirming them. And the reason that this court had no trouble affirming them, which is if an order is in place from a family law court that requires you to do something, and you either respond by committing fraud or you don't do it, the family law court can sanction you. I think this case is as simple as that, and that's all you need to know in order to reverse the trial judge's decision to vacate those sanctions orders. Clearly, the trial judge wasn't happy about it. The trial judge himself said this is an inequitable and unpalatable result. And I don't think there's any reason that this court needs to reach that inequitable and unpalatable result. Todd is a family law litigant. He lied about his ability to pay to a family law judge. He was sanctioned. Those sanctions are not void and they should be affirmed. If there are no further questions, I'll reserve the rest of my time.
Very good. Thank you very much, Mr. Crabtree.
Thank you. John Crabtree for Todd and Inga Kozel. Okay, so in the Kozel merits appeal, this court held, quote, "The family court was thus without continuing jurisdiction to consider Ashley's claims." That's what it held. The DCA was very aware it was talking about a family law court. It had no problem saying that as to these claims, they were outside the bucket. They couldn't properly be considered. So we're not talking about an erroneous order, which is almost every case that they rely upon, where people want to avoid or disregard an order that was simply wrong. We're talking about an order that was entered without jurisdiction. And by the way, just to be super duper clear, under the fourth paragraph in the merits decision of the section titled paragraphs 7A and 20 did not authorize the family court to award general damages for the delayed delivery of stock. This court also made it absolutely clear that it was talking about any equitable remedies as well. And so it went on in footnote 4 to make that abundantly clear. But anyway, this is why the court in the 212 West decision vacated the sanctions order in this case. And that case involved, as Judge Silverman acknowledged, an actual fraud on the court, which is pretty serious. They said that there's no difference between Todd and Inga. And I think in many issues that's true. And I think for both, the vacation is appropriate. But I will make one point about Inga. The only two orders they're challenging are mere discovery orders. They want to talk about the ambience of all other orders that are in the case. But those aren't orders at issue. They were not orders that they are saying should have been vacated. And those two against Inga were just run-of-the-mill garden variety discovery orders, far less egregious than any sort of fraud on the court. Anyway, in the merits opinion, the court was also being very clear that it was not deciding whether or not Ashley could even make a claim. Todd had an argument that she couldn't make a claim because he had cured. Ashley claimed that she could. And the court said, quote, "A matter we did not decide," and then said her claim, quote, "if it exists." So that was all pushed off for another day. So let me get to the issue about void versus voidness. And I'll deal with void first, and then I'll explain why it doesn't really matter. And you're going to have to bear with me as I do a slightly syllogistic argument, and I apologize for having to do so. But in the Kozel merits case, the court cited the Judge Ray's concurrence in 14302 Marina San Pablo. It was the first DCA case. She didn't like the state of the law in that court, but she concurred anyway. This court, and the issue in that case was whether or not an order entered without continuing jurisdiction could be raised on appeal for the first time or whether it would be waived. That was the issue. And in that case, the court found it was not waived. And the Kozel panel described that rule as rendering the underlying order, quote, void. That was in footnote 2 of the merits opinion in the Kozel case. It actually characterizes the first district's rule as an order entered without continuing jurisdiction is void. After the Kozel merits decision, this court issued its decision in Pulte. And that case cites both Kozel and 14302 Marina San Pablo. And consistent with the rule of the first DCA, this court ruled that, again, that an order entered without continuing jurisdiction could not be waived. Ashley argues that only orders entered without subject matter jurisdiction or personal jurisdiction can be void. But that's not true, at least not in this court. In this court, and going back as far as 2000 in the Synchron case, this court said a court with both subject matter jurisdiction and personal jurisdiction nevertheless might issue a void order. And that's exactly what happened in Abdo. So in Abdo 3, there were actually, I think, 3 or 4 Abdo decisions at the end. But in Abdo 3, the one that we cite, what happened was the case had gone back on remand. The court had jurisdiction to carry out the mandate, but didn't have jurisdiction to go contrary to the mandate. There wasn't a lack of subject matter jurisdiction. There wasn't a lack of personal jurisdiction as to carrying out the order. Yet the court went contrary to the mandate. And the courts and then it issued a contempt order based on its improper jurisdiction. This court reversed the contempt order because the underlying judgment had been reversed itself for being entered without continuing jurisdiction. So one led to the other. That was Abdo. Anyway, let's get on. Voidness ultimately does not matter. It's a little bit academic. And the reason that's so is because this judgment, the merits judgment, was appealed. The void dichotomy really comes into play where somebody fails to timely appeal the order they're going to challenge. In that case, they no longer are able to come at the order under 1.540 for being void. They've lost their opportunity. So a voidable judgment, not appealed, does submit. But we don't have that here. We did. And if you look at Sterling Factors or Kalar, that's the kind of scenario we're talking about. But that's not our case. We did appeal. This court did find that there was a lack of continuing jurisdiction to consider Ashley's claims. On Todd's vacation cross appeal, his appeal of the order that did not vacate his one child support order, according to the trial judge. The problem is the sanction was not about any sort of child support enforcement. That order, that child support proceeding that we're talking about here, was over $10,000 payment. And Todd never, not once, said he didn't have the financial wherewithal to pay it. What he said was, I can't access funds because Ashley has a worldwide assets injunction on me. And until I get relief from that, I can't give you the $10,000. Someone who got over $100 million, there's a $10,000 dispute. That's all he's talking about, okay? He's saying, I had to have it unlocked. They unlocked it. They worked that out. He paid the $10,000. Now, I know that Ashley wants to talk about all kinds of other issues and disputes these parties have, but that's not what we're here for today. We're not challenging any order entered on actual child support, any contempt they've had, Todd's various issues and travails in this world. We're talking about one order that had nothing to do with child support, the discovery, the notes that he didn't turn over or should have turned over or were phony or whatever they were, had only to do with judgment enforcement. The judgment was for, $40 million or so. This $10,000 payment, he never said he didn't have the money. He said, I need the injunction unlocked so I can get the money. And then they did, and then he paid. End of story. You can't roll in something that might happen down the future. This is not a squishy proceeding. Jurisdiction is a binary matter. You have it or you don't. You can't say, well, someday that thing you did might come and be relevant later on. But that's not what that discovery was about. That discovery was sought entirely in aid of execution. If you look at our cross-initial brief on pages 66, 67, we have citations for that. They never challenged that when they responded. In their cross-answer, they don't challenge that. The documents we're talking about were requested, quote, in aid of execution. It has nothing to do with child support. So for that reason, on our cross appeal, we believe that the court simply made an error. We laid it out in our briefs, and we would ask the court to vacate that as well. And with that, I have nothing more unless the court has questions for me.
Very good. Mr. Brannick, do you want to proceed with your rebuttal argument? You've got your 10 minutes to address both your initial arguments as well as the cross appeal. and you are still on mute.
I think by now I would figure that out. Let me start by correcting one point. Inga was in the case, certainly, on the proceeding supplementary, but she was also subpoenaed into the case on the child support issues. And that's extremely relevant because for the reasons that I've already argued, the trial judge always had supplemental jurisdiction on those child support issues. And if Inga and Todd are together making the argument that Todd doesn't have the ability to pay, then that's firmly within the trial court's wheelhouse, and the trial judge has the power to award those sanctions, and those sanctions clearly are not void. Now, I think one interesting point that Mr. Crabtree made was talking about what Inga did as just run-of-the-mill sanctions, and that's kind of the point that I've been trying to convey both in the briefs and here today. I mean, in this case, the sort of sanctions we're talking about were the failure to produce documents, the failure to file a financial affidavit, the failure to show up at depositions, falsifying documents, hiding assets, perjury, filing meritless motions. Yes, that's the sort of run-of-the-mill sanctions. That's the sort of run-of-the-mill misconduct that family law judges sanction every day. This case should be no different. If Todd is arguing that he's broke, that he has no ability to pay, then that is clearly relevant to the heart of the subject matter, the heart of the family law court's jurisdiction, regardless of what you think about the court's jurisdiction to handle the supplemental proceedings. As I said before, if those supplemental proceedings had not even been in play, the parties would still have been in front of the court, and Todd would still have been making these arguments that he had no ability to pay. And so let me turn to those Al-Kavandi notes, because I think that makes this absolutely crystal clear. So Todd's argument to the trial court was that he had no money to pay anything because he was $30 million in debt. And he was making that claim based on the argument that he owed all of this money to a Mr. Al-Kavandi. So first, the trial court sanctioned him for failing to provide any evidence of this so-called millions of dollars in debt. And then when he produced the notes, they were so obviously fabricated that the trial judge sanctioned him for the fabrication of those notes. It's a remarkable order. I'm sure your honors have read it. It's in the Todd's appendix at A67 to 77. But I think it's good to read it because it's instructive of the sort of fraud that Todd was engaged in this case. Now, the trial court recognized that those notes, that claim that he was in debt to Mr. Al-Kavandi to the tune of millions of dollars was connected to his child support obligations, because if you're claiming that you have an inability to pay because you're broke, then that necessarily impacts your child support obligations. He argues that the lies that he made had nothing to do with child support, but the trial judge disagreed. It looked at the contemporaneous nature of the lies that he made, which he made at exactly the same time that he was fighting child support. The argument that Mr. Crabtree made that the only—
Mr. Brown, can I ask you, do you have a site for where he argues that he's broke? I mean, I did note that in his response, he objected to the child support contempt motion on the ground that he was no longer employed therefore no longer had current income, and that most of the rest of his other assets were frozen. So is there, which I think I agree is a different argument from saying, I don't have any money. What he's saying is, I don't have more coming in, and what I already have is frozen. So can you point me to where in the record he says, I don't have any money?
I think Your Honor has accurately quoted what Mr. Kozel said. But I think to suggest first that the issue of the asset freeze was resolved by the parties. So you can take that off the table. he was able to use his assets to pay that judgment. He continued to contest. He continued to be behind on his child support payments for the next number of years, and actually had to bring 7 different motions against Todd for his failure to pay child support. And in every one of those motions, Ashley had the duty to prove that he had the ability to pay. And in every case, Todd continued to argue that he was in fact broke. Now, you could say, well, I don't have any current income.
This particular proceeding, hadn't he had purged that contempt by the time of the hearing, right? I mean, I'm not saying that he was Johnny on the spot with his payments or anything.
Right.
I'm not trying to suggest that, but at the end, and I'm not justifying it, but at the end of the day, or even before the end of the day, was there any time that he didn't actually make the payments? Ultimately,
right. His modus operandi was to not pay. Ashley would be forced to come into court, spend attorney's fees, make the arguments, show that he had the ability to pay, and then shortly before the hearing, he would pony up the money. But the trial judge recognized that that's not the way that family law litigants should act in front of this court, and that Ashley was entitled to her fees as a result of that misconduct by Todd. Now, I want to focus on one thing that Your Honor asked about, which is Todd says all I was saying is that I had no current income. But that to say that you have no current income doesn't mean anything if you've got $30 million worth of assets in your pocket, because if you have $30 million worth of assets in your pocket, you can easily, one, sell any part of that $30 million of assets, or 2, the interest that you make on those assets easily covers your child support obligations. So you can't just say when he says that, oh, I had no income, I wasn't meaning to suggest that I was broke, and therefore being broke has nothing to do with my child support obligations. Of course it does. If he's hiding from the court the fact that he has these millions of dollars in assets, that is hiding the income stream that would make him, which would easily give him the ability to pay those child support obligations. So clearly the trial judge recognized that, and that's why the trial judge, despite reversing all the rest of the sanctions order, affirmed this particular sanctions order. And the point that we're making, Your Honor, is the reasoning that the trial judge used in affirming that sanctions order on the Al-Qabandi notes is equally applicable to everything else that Todd did, because everything else that Todd did was designed to fool the court into thinking that he had no money, and you can't do that to a family law court because that goes to the heart of its jurisdiction.
Very good. Mr. Brannick, if that concludes your presentation, then we will proceed to Mr. Crabtree, and you have reserved 5 minutes for your rebuttal on the cross appeal.
Thank you, Your Honor. I'll just make a very quick point. We're talking about a single payment, a single order, single issue, $10,000. He didn't say he didn't have the money. He had the money. He paid it. Proof's in the pudding. Ashley wants to time travel and talk about amorphous orders at different times in the history of this case. We're not disputing those orders. We're not challenging anything like that. We agree when Todd was untimely on child support, the remedies were the remedies. There's no challenge to that. We're talking about one thing. An item was produced in aid of execution, and they're trying to weave that in to an order that had nothing to do with a plea of poverty, which is the language they used. It had, in fact, just the opposite. Todd saying, I've got the money, just unlock the door so I can give it to you. They unlocked the door and he gave it to them. That's it. I have nothing more to add.
Very good. The panel is prepared to go forward with the last 2 cases. You are both the attorneys still arguing the last 2 cases. Do either of you need to take a break, or shall we continue?
I'm good if Mr. Crabtree's good.
I'm okay. Thanks.
Very good. Then let's proceed. The next case on the docket is still titled Kozel versus Kozel. We are now going into case 22-2869.
That's correct, Your Honor. This is the disgorgement case. this case requires a deeper dive back into the merits of the original divorce case and Todd's breaches of his obligations under the property settlement agreement.
Mr. Brannick, just a reminder, both sides for these next two cases have 20 minutes per side per case. Do you wish to reserve any time for rebuttal on this one?
Thank you, Your Honor. Yes, 5 minutes, please.
Very good.
So as Your Honors recall, Todd was required to deliver 23 million shares of the Gulf Keystone Petroleum stock by January 17th, 2012. And the property settlement agreement between the parties prescribed a number of remedies in the event that the husband breached that contract. But there was more to the case than that. The trial judge also entered contemporaneously an agreed asset injunction. That asset injunction, which was agreed to by the parties, prevented the former husband from trading in the stock until he complied with his obligations. It essentially recognized that during the period before he delivered that stock, he was holding that stock for Ashley's benefit. So it prevented the former husband from trading that stock, and it required him, if he did in fact trade in that stock, to escrow any proceeds from that trade of the stock into an escrow account. And it gave the trial court in rem jurisdiction over the monies in those accounts, obviously, so that the trial judge could equitably determine how those profits or proceeds should be divided among the parties. Well, so you know the story that instead of delivering the stock, Todd held onto the shares during a very hot market and profited from trading the stock that should have gone to Ashley. So Ashley sought to enforce that breach. And the trial court's final judgment did two relevant things for the purpose of this appeal. First, it awarded Ashley her significant breach of contract damages for Todd's breach of the contract. This court, as we know, reversed that judgment as being beyond the power conferred by the parties in the property settlement agreement. But secondly, and most importantly for the purposes of this appeal, the trial court also held that Todd had violated the asset injunction by trading shares in the Gulf Keystone Petroleum stock that actually belonged to Ashley, and had in fact failed to escrow the proceeds from the sales of the stock into the escrow account. And the trial court ruled that if Ashley is not made whole by her breach of contract claim, she could seek remedies for violation of the injunction, including disgorgement. That aspect of the judgment was not appealed by Todd. And as we know, even as the court, this court on the merits, reversed the breach of contract damages, it affirmed the balance of the judgment. Well, since Ashley had not been made whole as a result of the reversal, she went back to the trial court seeking her remedies under the injunction, including the disgorgement of the profits that Todd made that he should have put into that escrow account. But the trial court ruled that even though the trial judge thought that disgorgement was the appropriate remedy, that it had no jurisdiction to award disgorgement based on the ruling in the original merits appeal, essentially blending the disgorgement remedy with the breach of contract remedy. Well, first, respectfully to the trial court, that's not what this court ruled. Todd never appealed the trial court's factual and legal rulings relating to the violation of the asset injunction. Thus, you won't see a word in Judge Solario's very carefully written opinion about the asset injunction in the original Kozel appeal. This court's jurisdictional ruling, in Judge Solario's opinion, was all about the powers conferred by the property settlement agreement. The ruling had nothing to do with the trial court's traditional injunctive powers. And of course, as this court knows, just like family courts always have the power to enforce their orders, judges who enter injunctions have the power to enforce those injunction orders. So we think that the disgorgement issue is alive and well, and this court should have, and that the trial court should have ruled on those remedies. The trial court should have determined what amount of money should have been put into the escrow account, and then determine what was the equitable way to divide that money. So that issue was still alive. Now, in thinking about this case, there is a huge difference between enforcing the remedies the parties agreed to in a property settlement agreement and the enforcement of an injunction. We know that in the context of the settlement remedies, the Colucci case, restricts the parties to what they agreed to in the agreement. But there's no such restriction in the injunction case. Courts always have the broad powers to enforce their injunction. Now, Todd wants to blend the two and suggest that the injunction issue is just exactly the same as the issue of the enforcement of the property settlement agreement. That's just
Mr. Brannick, isn't that because the injunction was incorporated into the PSA?
Well, whether it was incorporated or not, the question is, did the injunction provide different remedies for the court? And does the judge still have power to enforce those remedies? I think it's interesting. I mean, go back and look at the merits opinion, and you won't see a single word by Judge Solorio relating to the judge's injunction. Now, that opinion was very carefully written, and Judge Solorio spent many pages discussing exactly why the specific language of the property settlement agreement didn't provide the trial court with the power it thought it had to rule on the breach of contract. Judge Solorio doesn't say a single word about the injunction. And that's, of course, because the injunction wasn't appealed. The injunction wasn't appealed. Those findings, those legal conclusions weren't appealed. If Judge Solorio had thought that the remedies in the injunction were similarly foreclosed by Paolucci, you can be darn sure that there would have been several more pages of the opinion parsing very carefully the language of the asset injunction and determining whether or not that language could be enforced by the court. There's none of that in this opinion. That's because Judge Solorio, this court, was focused solely on the remedies provided by the property settlement agreement, and the opinion has nothing to do with the remedies provided by the asset injunction. And the asset injunction is very simple. It says, Mr. Kozel, you may not trade in that stock until you deliver it. And Mr. Kozel, if you do trade in that stock before deliver it, then you better darn well put that money in escrow. And then this court will determine what happens to that money. Mr. Kozel violated all of those obligations, so we think the trial court clearly had the power to say how much money should have gone into that escrow account and how that money should have been how that money should have been denied. So it's not the same remedy at all. The remedy in the opinion has everything to do with the profits that Ashley said she would have made had she had the stock when she was supposed to have the stock. The injunction is all focused on Todd and Todd's conduct and what Todd was supposed to do or not supposed to do with that stock. The amended judgment, the disgorgement remedy doesn't award a breach of contract remedy. What it in fact does is punish Todd for his violation of the trial court's injunction. So the original decision in this case on the merits related only to the property settlement agreement had nothing to do with the injunction, and that separate remedy of the injunction still exists. So at bottom, we think it's a simple argument. Ashley had a set of remedies under the property settlement agreement. We know that those remedies are now set aside. But the first opinion only dealt with the property settlement agreement. It did not deal with the injunction. That injunction remedy was not pursued, and the trial court specifically reserved jurisdiction to take a look at the violation of the injunction if Ashley wasn't made whole. So for all those reasons, the trial judge was wrong to think that it did not have jurisdiction to deal with a separate injunction, and that decision should be reversed. I'll reserve the rest of my time unless there are some questions.
Very good. Mr. Crabtree, you've got your 20 minutes of argument for this.
I will try not to take it. I want to open with a quote from Kozel v. Kozel, the merits decision. We reverse the family court's award of damages to the former wife, Dash, together with an injunction intended to secure the payment of those amounts. That's what it said. It did get rid of the injunction. That's right there on page 941. So to start with that. Next thing. The court, if you read the merits decision, is very clear that it was wiping away her, quote, equitable claims as well as an illegal claim. And I think the clearest place, and you can find several instances in the decision where this just comes startlingly through, But if you really start at page 948, read the body of it, and then go down to footnote 4. And here's what it says. Read as a whole, paragraph 7a, which is what she was relying upon to make her claim, is most naturally interpreted as meaning that the former wife's ability to seek legal and equitable remedies in the family court, as distinguished from an independent civil action, arose if the former husband failed to comply with his obligation to deliver the stock on or before May 1, which of course he did do that. So if you read the decision, it is abundantly clear that this court shut down any legal or equitable remedy related to the stock issue. Full stop. And said, it is, if you want to pursue it, you've got to go to circuit civil. They just didn't do that. That's the problem. They were in the wrong court. We told them from day one, you're in the wrong court. This court has no jurisdiction. We said that from the very, very beginning. It's not on us that they plowed ahead. It's not on us that the judge kept giving them rulings that they got. This case never should have been. It's like Bobby Ewing in Dallas in that dream sequence. It just all goes away. You know, it's just gone. That anyway. So let me go on. If they were right, if she still had this equitable claim for disgorgement, which I'll get to in a second, but if she still did, this court would have lacked jurisdiction in the merits appeal. And in fact, that's an argument that actually made. She made a rehearing, but it doesn't matter because a lack of jurisdiction, as we all know, can be raised at any time. So she moved to dispatch the appeal post-decision because there was still her disgorgement claim. We responded and said, no, that's not this. This is not an additional claim. It's all subsumed. And guess what? This court rejected her claim that it lacked jurisdiction. But had she been right, the court would have been compelled to dismiss just like she asked. The last point I'll make about her disgorgement claim is just a dressed up damages claim. And that's really, again, when you read the merits decision, that's really what the panel was saying. This is all just her seeking money damages. And you cannot do that post Paolucci. For each of these reasons, we'd ask the court to affirm on the disgorgement ruling. Thank you.
Very good. Mr. Brannick.
All right, just a few points, Your Honor. First, there is a reference to an injunction in the merits opinion, but that's a different injunction. The court, when it entered its order awarding Ashley her breach of contract damages, also issued an asset freeze. That is the injunction that Judge Solario's opinion is referring to that was reversed. What we're talking about is an injunction that was entered into at the time the parties entered into their property settlement agreement years before that. That's the injunction that says, Todd, you are not allowed to trade the stock. And if you do that, you have to put that money into the escrow account. That's the injunction that was never appealed and never discussed by Judge Solario's opinion. So don't get confused by the two separate injunctions. I think the word injunction appears maybe one or two places in that merits opinion, but it's referring to the asset freeze. It's not referring to the injunction that's at issue in this case. Then Mr. Crabtree says that the court, in its opinion in the merits, said that it forecloses all legal and equitable remedies. Yes, all legal and equitable remedies that arose out of the parties' property settlement agreement. The opinion, again, doesn't say a word about any legal or equitable remedies arising out of the violation of the judgment. Again, as carefully written as that opinion was, it's impossible for me to fathom that a judge, if this court were determining that the amended asset injunction was out the window as well, that there certainly would have been a discussion about that. I think we cannot presume that that's what the court meant. What the court meant by legal and equitable remedies is legal and equitable remedies arising out of the parties' property settlement agreement. And then finally, Mr. Crabtree refers to the argument that we made on rehearing. We had argued that the reservation of jurisdiction on the disgorgement remedy deprived the the court of jurisdiction because there was not a final judgment. It's a purely procedural issue, was not an argument on the merits. This court denied rehearing. We don't know why the court denied rehearing, but if I were to guess, I think the court probably decided that the fact that the court referred to an alternative remedy of disgorgement that would come into effect in the event that there was a reversal did not deprive this court of finality. So I don't think that this court on rehearing was intending to weigh in on the merits of this disgorgement issue at all. So our argument is simple. The remedies under the property settlement agreement were foreclosed, but the remedies under the court's asset injunction were never talked about, never appealed, and certainly not foreclosed. So for those reasons, the trial court's decision not to enforce the asset injunction should be reversed.
Very good. Thank you both. And now we turn to the last case on the docket, which again, Kozel versus Kozel. It's 22-3189. There's 20 minutes total per side, but there is a cross appeal. So, Mr. Brannick, do you wish to reserve time after Mr. Crabtree presents his argument, which is a combined argument on the appeal and the cross appeal?
Yes, please, 5 minutes.
And Mr. Crabtree, on the cross reply, do you wish to reserve time for rebuttal?
Yes, Your Honor. Just 3 minutes actually in this, 3.
All right. So for the initial arguments of the appellant, you've got 15 minutes and Mr. Crabtree will have 17.
Okay.
And then you'll have your rebuttal times. So with that, let's proceed. Mr. Brannick.
Steve, I thought we agreed I was going first on this one. So
Yeah, I think Mr. Crabtree would go first.
Okay. Yeah. Sorry, Your Honor.
I'm sorry, I had that in reverse order on my notes. I apologize. So Mr. Crabtree, you've got 17 minutes, and then Mr. Brannick will have the 15 plus the 5 for his cross reply, and Mr. Crabtree on your reply after Mr. Brannick goes is 5 minutes.
Thank you, Your Honor. Okay. So our core argument, substantively at least, is that where discretion is predicated upon a legal error, it's an abuse of discretion. And in this case, the trial judge rested her ruling on 2 legal errors. First of all, she found that Ashley had, quote, established a breach, but that's not possible. It was jurisdictionless litigation. The court, as this court repeatedly said, the trial court lacked jurisdiction to consider Ashley's claims. Not only that, this court repeatedly was emphatic that it was not deciding the merits issue. Todd's leading argument was that he hadn't breached because he had satisfied the cure provision. The court chose not to address that. Ashley argued that she was right on the merits. The court chose not to address that. In fact, its very words were, quote, a matter we not decide. And then as to her claim for any remedy for what she claims Todd did, quote, if it exists. That is not the language of a court blessing a finding. That's the language of a court saying there is nothing here. That's for another day. That's for another court. So she doesn't have an actual establishment of a breach. So that can't be the predicate for denying fees to Todd as the prevailing party. The other thing the court held on to and repeatedly brought up, I think 3 times, was that Todd had not achieved any relief in this post-divorce litigation. But of course, Todd wasn't suing. Todd wasn't seeking relief. And you don't have to sue somebody to win on prevailing party fees. So that was another error by this judge. And so here we have a judge exercising her discretion to deny prevailing party fees to one of the parties, and doing so based on 2 legal errors. The next point I want to make is a law of the case argument, which is that this court did not decide who was the prevailing party when it ruled on fees. It punted the issue back to the trial court, but then actually took the case up to the Supreme Court of Florida and sought discretionary review. That court unconditionally awarded fees, and it did something, as all of us who are familiar with that court's practices know, was quite surprising. It actually remanded for determination of amount. The standard practice in the Supreme Court of Florida is it awards $2,500. A point actually made, and we agree with. That's how it's done, but not here, not this time. It actually awarded fees unconditionally and remanded. And there is plenty of case law that we cite in our briefs that where an appellate court determines that a party is prevailing, that is the law of the case. So that's a second reason why we ought to prevail. We have cases saying that when you win on continuing jurisdiction, that entitles you to prevailing party fees. That's the Witt decision. Actually makes a statement in her briefs, I think in her reply, where she says that Todd paid $5 million in capital gains, and that proves that she's the winner. Well, where is that in the record? You know, we're talking about a tranche of stock that was sold specifically. We don't know if Todd sold that tranche. If he did sell it, we don't know what he sold it for. We don't know if he sold it for a gain or a loss since the stock was going down. And if he did sell it, theoretically, for a gain, we sure as heck don't know if it was for $1 or a gazillion dollars. No one knows. It's just not part of this case. Ashley now has taken her $3.8 million claim and in briefing converted to a $5 million claim. But that's not this case. It was a $3.8 million claim. That's what she sought. That's what she won. And that's what she lost when the case was up on appeal. Those are the facts. That was $3.8 million, got vacated. All she got was Todd to file a corrected tax letter, which he should have done. That was an actual breach. The court had jurisdiction to compel him to do that. But that's really all she won. She won getting Todd writing the letter. And weighed in the totality of this case, Todd was the prevailing party. At the very least, it ought to go back to the trial court so that she can exercise her discretion, not predicated upon two legal errors. I think that's it for us right now. Otherwise, the rest in our brief, and I'll clean up what I need to in rebuttal, depending on what Mr. Brannick says. Thank you.
Very good. Thank you very much, Mr. Brannick. You have your 15 minutes.
Thank you, Your Honor. Let me start with the big picture. The question before the court is who is the overall winner in this case, not who prevailed in the merits appeal, but who's the overall winner below. This court recognized that that's still an open question by sending that decision back to the trial court. So let's look at the case overall and focus on the findings of the trial court in its fee order. And there were three main points to this litigation. And this is what the trial court found. First, there's the issue of the tax basis claim. Trial court ruled that Ashley succeeded and she obtained a very substantial benefit as a result. She shifted $25 million in capital gains and about $3.8 million in tax liability from her side of the ledger to the husband's side of the ledger. Now, if you want to look at where that is, just look in the trial court's final judgment on that point. The former husband had suggested that the basis in 5 million shares of stock was a penny, and it was actually $4 and some odd cents. You do the math, and you come up with $25 million in capital gains tax. It's not complicated. So
Mr. Brannick, I guess your position would be in the one issue that post our decision, our merits decision, the one issue that was properly before the family court, she won on.
Absolutely.
Right? Yeah. So that would be that's your position basically as to why she is the prevailing party.
She won, and she won big. I mean, as a result, she ended up with a $5 million refund from the IRS. Now, they try very hard in their briefs to downplay that and suggesting that, oh, none of that was really an issue. This was all about the delayed delivery claim. No, all you have to do is look at the record and you'll see that that's not true. They denied the tax basis allegations from the very beginning. She made the allegation in the petition and requested a revised tax basis letter. He opposed it. That's in the record at 541 and 551. Then she moved for summary judgment and he opposed it. And when he opposed it, he said, my only obligation was to provide a tax basis letter to you in good faith. And I did that. I have no further obligation. I don't have to write any letter. You should have asked for more clarification. And in any event, this is all between you and the IRS. So it made all of those arguments suggesting he had no obligation whatsoever. She then gets the motion for partial summary judgment, and Todd moves for rehearing. And he makes all the same arguments. Again, that's a record 747 to 752. And then when the trial court rejected all of his points and they were going to trial, he filed a pretrial brief and again raised all of these arguments in his pretrial brief. And then when the trial judge ruled against him on everything and said that he had to provide that letter, again, he moved for rehearing. This issue was hotly litigated and he lost. And as a result, she recovered over $5 million. I think that I could end our prevailing party fee argument right there. I don't think there's any case in the history of Florida jurisprudence where someone sued and won millions of dollars on one of their claims and was not considered to be the prevailing party. But she didn't just stop there. She also won on issues relating to the asset injunction. The trial judge noted in the original order that he had violated the asset injunction, and the trial judge in her fee order, recognized that Todd had violated the asset injunction. He never appealed that finding. So she's got a very significant finding of breach, which we think at the end of the day is going to result in some sort of remedy to her, perhaps a disgorgement remedy if we're successful on our appeal, or perhaps some other remedy. But she's got findings of breach in addition to that $5 million she put in her pocket. And then even on the delayed delivery claim, again, in the fee order, the trial judge recognized that she established a breach of the property settlement agreement. That can't be argued. He had an obligation to provide, to deliver those shares by January 17th, and the evidence is undisputed that he did not. So there is a clear finding of breach. Now, it may be that the trial judge didn't have the power to award damages for that breach, but there is nothing to suggest that the trial judge didn't have the power to find that breach. Even Todd concedes that the trial judge had the power to interpret the property settlement agreement and to determine the party's obligations, and the party determined that that obligation was breached. And so when you put all of those things together, we have a clear win for Ashley on the tax basis claim. We have multiple findings of breach. We have the trial judge saying there's no finding of breach on her part. We also have, just as an aside, Todd's fraud on the court. The only legal conclusion that you can reach based on those findings by the trial court is that Ashley was the prevailing party, and certainly Todd could never be considered the prevailing party. This case is nothing like the rare cases where the courts declare a tie and find that no one prevailed. As Todd himself articulated in his initial brief, when he was actually trying to argue that he was a prevailing party, this is what he said. This court has maintained that in a breach of contract action, one party must prevail. No such compelling circumstances exist in this case. That's in his initial brief, 25. Well, we couldn't agree more. As we discussed in our briefs, when one party proves that the other side breached, that party prevails and gets their fees. And this court has ruled that they can get their fees even if they don't recover a single dollar in their damages. First, look at the language in the Moritz case, which is the granddaddy case in prevailing party fees. Moritz specifically holds that it's not the relative success of the parties. It's whether a party, quote, succeeded on any significant issue in the litigation which achieves some of the benefit that the parties sought in bringing suit. Well, Ashley fits within that language like a glove. She received a significant benefit. She shifted those $25 million in capital gains. She put $5 million in her pocket as a result of that hotly litigated issue. So Moritz is absolutely on point. And then we have the Hardman case out of this court. I think in that case, this court awarded prevailing party fees to a party that proved a breach but didn't recover any money at all. It was enough to prove the breach. The cases where the courts declare a tie are usually one of two situations. Either one, both parties prove a breach, and we know that's not the case here. Ashley proved the breach. And Todd never even attempted to prove a breach on Ashley's part. So we don't have a situation where both parties are guilty of breach. And the other situation where courts often declare a tie is when neither party is able to prove a breach. I have not found any case where a court has decided that a party is not a prevailing party when they've recovered a substantial amount of money just because they didn't recover everything they wanted. That's certainly the case in almost every bit of litigation. And there's only two cases that I think that Mr. Crabtree has cited that are worth taking a look at, and that's the Skylink case and the Pereira case. And both of those cases, I think, prove our point, because they are both cases where the only issue that a party lost on were issues that they conceded from the start. And so if you concede an issue and then lose some money, but you were never really challenging that amount of money in the beginning, then Skylink and Pereira tell you, yeah, you're not a prevailing party if you lose on an issue you were prepared to give up on from the beginning. But that's far from the case here. Todd did not give up on anything. He certainly didn't give up on the tax basis issue. He argued that he didn't have any obligation to produce that letter. She won, and she won $5 million. So for those reasons, there is no way that this court could declare Todd to be the prevailing party. But we think, based on the trial court's findings of breach and the $5 million that actually put in her pocket as a result of this litigation, that she should be declared the prevailing party. I'll reserve the balance of my time.
Very good. Mr. Crabtree, you have your 3 minutes of rebuttal.
Thank you, Your Honor. So Ashley was seeking over $40 million in damages, and she lost that. She also sought $3.8 million in damages from Todd based on the tax basis letter, and she lost that too. All she won was the corrected tax basis letter. So who is the overall winner? Under Florida law, it's a totality of circumstances ruling, and it is a discretionary ruling for the trial court in the first instance. And what happened here? In exercising her discretion, the trial judge found that neither party prevailed. Instead, she found it was a draw. But her ruling was based on two legal errors. One, as a matter of law, Ashley Cozell did not establish a breach of the PSA as to this delayed delivery claim. Didn't happen. It's completely wrong. Second, Todd had no need to win affirmative relief to be the prevailing party. It's not Florida law. Taking out those two errors pushes the balance from neutral to Todd. At the very least, though, the matter ought to be remanded so that the trial judge can exercise her discretion in the first instance. By the way, I just want to touch on one point. I heard a member of the court observe that Ashley prevailed on the one claim for which the trial court properly had jurisdiction. That is true. But that is in no way dispositive here as to whether or not Todd can get prevailing party fees, because all the other claims are still subject to the prevailing party fee provision. That's the holding in wit, and that's the longstanding rule that all Todd was doing in seeking fees was seeking to enforce the terms of the PSA, which is totally appropriate under Pellucci, because that is within the scope of the agreement. And when Ashley did not prevail in the underlying case, you're entitled to prevailing party fees. She didn't. She lost the $40 million. She lost the 3.8. She just got the letter. Anyway, the judge weighed it, called it a draw based on two legal errors. We'd ask the court, at the very least, to remand to the trial court, but we believe that given the trial court's prior finding of neutrality based on two errors, that with the correction of those two errors, the balance has to go to Todd. Thank you very much.
Very good. Thank you. Mr. Brannick, you have your 5 minutes of rebuttal time.
I'll be very brief, Your Honor. I mean, Mr. Crabtree says that all Ashley won was a letter, and that was a pretty darn important letter. That letter resulted in her ability to get a $5 million tax refund and shifted that tax liability to Todd. That is a very significant win, and it is an issue that Todd fought tooth and nail on, because he recognized what the impact of having to provide that letter was. You couple a $5 million win coupled with findings of breach of the property settlement agreement and breach of the asset injunction. She prevailed in some respect on all of her claims, but she certainly, for the purposes of the Moritz case, received a substantial benefit on at least part of what she sought. That makes her the prevailing party as a matter of law under Florida law. So for those reasons, this court should certainly not determine that Todd is a prevailing party, and should in fact find that Ashley is the prevailing party.
Very good. Thank you both. Let me compliment you both for taking some very difficult, complex, factual and legal issues and staying not only within the time and the extra time that you requested, but presenting them in a good streamlined fashion. And we really appreciate that. Again, thank you both. And that concludes the oral argument docket for today. Council can leave by hitting the leave button on your screen. And for the panel, we are adjourned. Thank you very much.
Thank you.
Thank you, Your Honor.